Juzu Bekunore, O-Langsoliet Purana Bazar, Post Office Langsilet, Dist.Karbi Assam, Sidu Agonde Chakmaun, Tara Jagani, Taranangot Guribati, Sroddio Prepalbante Paramosoy, Best Tarik December 2021 application file Gochun, Karbi Autonomous Council Du, Tara Jagani Pebate, Forest Right Act 2006 মাধ্যমে সেফরে 10 তারিখ 10 মাস 2020 সালত সনাতন চাকমা একখান আরটিএ ফাইল করছি কার্বি আংলং অটোনমাস কাউন্সিলইডু আরটিএ অ্যাক্ট 2006 মাধ্যমে তারা যে অ্যাপ্লিকেশন ফাইল করছেন তারা আগন্দের জাগানি তারা নাগত গুড়িবাতে সিয়ানি লন্দেল ই হামগজন নগরম সিয়ানি জানিবাতে কার্বি আংলং অটোনমাস কাউন্সিলত তুন পিআইবু হনো রিপ্লাই নগরে সেফরেন্দি সনাতন চাকমা থে আরটিএ ফার্স্ট এপ্রিল ফাইল করছি 3 তারিখ জানুয়ারি মাস 2023 Affiliate Authority Karbi Anglong Autonomous Council itu. Affiliate Authority bu yo hono reply nogore. Say for andi the RTA second appeal file gucci Assam Information Commission itu. Assam Information Commission tha second appealan hearing gori garai the Karbi Anglong Autonomous Council PIO gore direct gucci 10 din obdirendi the je information ani makki sini provide gotto. কিন্তু 10 দিন বিধি জানা পরে ইউ পিআইবো হনো তারে ইনফরমেশন প্রোভাইড নগরে সেফরন দিতে আরব কান কমপ্লেন ফাইল গুছি আসাম ইনফরমেশন কমিশনার তো আসাম ইনফরমেশন কমিশনার থা কমপ্লেন আন হনো ইন্টারট্রিয়েন নগরে যে কারণে সনাতন চাকমা থা কান অনারেবল গুয়াহাটি হাইকোর্ট হইদু কান রিট পিটিশন ফাইল ঘুরি ফিয়ে গই যেন নাকি 12 November 2024 অনারেবল গুয়াহাটি হাইকোর্ট হইদু ফাইনাল হিয়ারিং এলো এজো সেই সালেন
May I please, Your Lordship, the mechanism possible for timing?
I have heard you.
Lordship, believe in law point is to be decided. Only the legality of section 18.
Your judgment I have perused. That was a direct complaint.
Absolutely.
Direct complaint before the state commission
Yes.
after his RTA application.
Yes, sir.
He did not come through first appeal and second appeal route.
Absolutely. That is what the mandate of section 18 says, Lordship.
Hmm.
That is what has been elaborated by this Honorable Supreme Court.
Hmm.
That 18 and 19 are two different distinctive
Yes, but
DPDs.
the procedure under 19 is different than
It's
procedure
applicable.
under 18.
Yes, sir.
And section 18 says about any person. It includes a complainant. It includes an second appellant also. Second appeal appellant also. I don't think that because a decision is an authority what it decides, and it is about on the facts of the case.
Lordship,
Yes, Mr.
It appears from the petition submitted by the petitioner that it is not an application under section 18. So it is open for the petitioner to submit an application in accordance with whether if.
No, he has specific allegation
No,
that
allegation is
quoting the provision is not a
Madam.
sine qua non.
My lord,
But if the ingredients are fulfilled,
my lord, it is for the, my lord, state commission to take a decision on this particular petition, my lord.
Yes.
Whether it can be entertained under section 18 or not, my lord. So it is open.
in
for
my
the
view,
state
it
commission.
appears to be a complaint.
My lord, my lord.
Clear case that
it-
misleading, not related to my RTA petition.
my lord.
Kindly take necessary action.
My lord, my lord. Under section, if.
It is page 34.
My lord.
His averments are clear.
My lord, my lord. So. my lord,
Now, if the power is there, source
lord.
is available,
My lord.
and an application is filed,
My lord, so my submission is that it is open for the state commission to treat this petition, it is open for the state commission to treat this petition under section 18(3) and to proceed and to take a decision on the matter without expressing any opinion of the merit of the
no,
case. my
merit
lord.
of the case.
My lord,
I am saying that he has made an allegation that the information supplied to him
it
is
and wrong.
misleading and not
My lord.
complete.
And lordship, a record by submission that the application has already been transferred to the under section 6(3), so it is not misleading. That is only my submission, lordship. and recording.
6-3.
6(3), my lord.
Wait,
So
6-3.
That is only my submission, lordship.
6-3 is at the initial stage.
Initial stage, so that is transferred, my lord. So also only record my only that submission legal
We'll
submission.
record the facts.
My
We'll
lord.
record the facts.
My lord, my lord.
we'll do the whatever is heard, what is reflecting from the records,
My lord, my
we'll
lord.
do.
And Lordship, page 21, that person, that petition itself says that it is required to be transferred under section 6(3). Accordingly, we have transferred the petition to the, my lord, principal secretary transferred the petition to the competent authority, my lord, to furnish the. That is only my submission. And it is open for the state commission to proceed in accordance with law, my lord.
Hey, down in article.
May I submit just one point also? What the Supreme Court has said in both the one judgment and that judgment and another judgment in recently, that section 18 has a supervisory power. It's the nature of the section 18 is supervisory. So the question would be before this honorable court, can it be used or applied for non-compliance of the order? Because order of the Supreme Court is of the full bench of the Supreme Court. I'll just place it.
Then section 18 will be odious and redundant if your submission is accepted.
That is
And that result will be that court will be the executing court if your submission is accepted. There is no other forum.
absolutely.
An applicant will exhaust about 2 years' time. And after that, a teethless commission. And 18
But that is
will
what
be redundant.
that is has been read to the law lordship by the honorable Supreme Court. It is judgment of full bench. Paragraph 10, Lord, which reiterates the finding of
Very nature of power. Hey, to light. So SSC to light.
2011.
Just a minute.
Yes.
Madam, please take your seat. Peacock. The petitioner has approached this court seeking to invoke the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution of India, contending inaction on the part of the Assam Information Commission in the matter of taking cognizance of a complaint stated to have been filed from a stated to have been filed by the petitioner before it on 21/05/2024. Full stop. The petitioner, the petitioner has claimed that he belongs to the scheduled tribe. Is scheduled tribe order 1952 direction. Chakma, which is recognized as a scheduled tribe in the district of Anglong, Assam, under the Constitution Scheduled Tribes Hills Order 1950. Postal. To substantiate such fact, the petitioner has annexed a tribe certificate issued by the Office of the Deputy Commissioner, Anglong, on 13/12/2017 as Annexa 1 to the writ petition. Postal. The petitioner has stated that in order to obtain information as regards allotment of forest land under the provisions of the land policy frame. You please take your seat. I'll go through it.
Okay.
You submit it on.
Yeah.
Under the provisions of the land policy framed by the government of Assam and the scheduled tribes and other scheduled tribes and other traditional forest dwellers within bracket recognition of forest rights bracket close Act 2006. Recognition of forest rights, into bracket. He submitted an application on 22/12/2021. Before the Chief Executive Officer, Anglong Autonomous Council, Difu. Seeking information, seeking certain information. When the said application was not responded to, the petitioner submitted another representation on 16/2/2022 before the same authority, but the said application was not responded to. Said application 2 was not responded to. Postal. Thereafter, the petitioner and then submitted an application under Section 6 of the Right to Information Act 2005, within brackets, the RTI Act. Before the Public Information Officer, Karbi Anglong Autonomous Council, DIFU, on 6/10/2022, seeking the following information, page 21, A to A. In the said, in the said application, the petitioner requested for information at the earliest, and further stated that if the information requested information were not available in the office, then the application was to be transferred under Section 6 within bracket 3 of the RTI Act to the Public Information Officer, to the concerned Public Information Officer, with intimation to the applicant. Full stop. Para. When the petitioner did not get any reply from the PIO of the Karbi Anglong Autonomous Council, and the petitioner did not had neither received any reply nor any information as sought for by him under the RTI Act, he preferred an appeal before the first appellate authority. O/O, the Karbi Anglong Autonomous Council, DIFU, on 3/1/2023. First of the said appeal was received by the office of the first appellate authority. First, after waiting for a reply, after waiting for a reply from the first appellate authority, the petitioner did not receive any response. He stated to have approached the, what is his name? Information Commissioner or Chief Information Commissioner?
State Information,
Huh?
some State Information Commission. That is the
Stated to have approached the Assam State Information Commission by preferring an appeal under Section 19 of the RTI Act on 24/3/2023, highlighting the approaches he had made before the Public Information Officer and the first appellate authority. Post. On receipt of the appeal, second appeal, under the provisions of the RTA Act 2005, the registrar, Assam Information Commission issued notices to the State Public Information Officer, O/O, the Anglong Autonomous Council, seeking his presence at the hearing, along with all the relevant records at the hearing scheduled on 7/2/2024, with the information that the State Assam Information Commission had decided to hear the matter. Full stop. The SPR IO was directed to submit a written statement mentioning the date of receipt of the application under the RTI and the date of furnishing the sought for information to the applicant, that is the petitioner, if he had already furnished the information. Full stop. The SPA was further informed that if the sought for information was not furnished to the applicant, then the written statement should explain as to why penalty under Section 20 of the RTI Act shall not be imposed on him for his failure to furnish the sought for information within the stipulated time period. Full stop. The SPA was further informed that if the request for information was rejected under Section 7 within bracket 1, then his written statement should indicate the date of receipt of the application under the RTI application and the date of rejection by him, giving reasons for such rejection. Full stop. Subpara. When? Okay. On on 7/2. Something is wrong. Okay. On 7/2/2024. In the hearing, on 7/2/2024, before the commission. Agot start koribo commission. The petitioner was represented by a legal aid counsel with a letter of authorization from the Assam State Legal Services Authority to represent the petitioner in the hearing. Full stop. The SPIO O/O, the Principal Secretary KAAC, was not present at the time of that hearing, nor any written statement or any petition stating reason for his absence was submitted. Full stop. The Commission, on tracking the postal consignment, had found that notice from the Commission was duly served upon the SPIO O/O, the Principal Secretary KAAC DFU, on 20/01/2024. Post. Viewing such absence, the Commission directed the SPIO to furnish reasons why necessary action should not be initiated against him for violation, for non-compliance of the direction made in the notice, and such explanation should reach the Commission within 10 days of receipt of the order passed. Full stop. In the order, after the hearing, the Commission had passed an order on 8/2/2024. Etu ei agor pera tu prothomote likhibo. Agor pera tu subpera tu prothomote likhibo. First. In the order, the Commission noted that the petitioner sought information under 6 number of heads and the information sought for pertain to allotment and settlement of forest land for the scheduled tribe villages under the provision of the land policy framed by the government of Assam and the State Act 2006. So stop. At the hearing, the representative of the petitioner, the legal aid counsel appearing on behalf of the petitioner, submitted that no reply whatsoever to the RTA application was furnished by the SPIO, and in view of no response by the first appellate authority, the petitioner had to prefer the second appeal. Post. The on the basis of the commission had gone on to observe as under. It had gone on to observe in its order dated 8/2/2024, had gone on to observe as under page 28, 29, A to A. No. The commission had observed that the manner in which the public authority had acted was in disobedience of the provisions of the RTI Act. First of, taking note of the facts and circumstances of the case, the commission had gone on to observe the commission in its order dated 8/2/2024 had directed the public authority to furnish reply to the petitioner by registered post or email within a period of 20 days of receipt of the said order. First of, the commission further observed that the second appeal will be heard once again on 5/3/2024. And the Superintendent of Police Karbi Anglong was requested to ensure the physical presence of the public authority concerned on 5/3/2024 during the hearing of the second appeal. First of, para. The hearing on the second appeal, which was registered as case number 3304/23 stroke is 22% or 32% stroke within bracket KAN bracket close stroke 4 stroke 2023 took place again was held again on 5/3/2024. Full stop. In the said hearing, the public authority was represented by the in charge principal secretary KAAC, accompanied by the Land Standing Council KAAC. Full stop. Insofar as the explanation sought for by the commission regarding absence of the SPIO during the last hearing held on 7/2/2024, the SPIO submitted an explanation to the effect that the petitioner as an applicant had filed several RTI applications and the replies were given in respect of some of the earlier applications. The SPO further stated that the order dated 7/2/2024 and the case under reference were not brought to their notice, and the office was under the impression that the case was already heard and replied. The commission found the explanation provided by the SPIO to be a lame one. During the hearing, the SPIO and the Learned Standing Council KAC had prayed before the commission for granting 10 days time to reply to the RTI application of the petitioner. First of all, in view of such submission made by the SPIO and the Learned Standing Council, KAAC, the commission had disposed of the second appeal with the following observation and direction. Page 31, A to A. After disposal of the second appeal by the order dated 6/3/2024, a commission disposal of the second appeal with the following of the by an order dated 6/3/2024 করে দিব। After disposal of the second appeal by the order dated 6/3/2024, the principal secretary, in charge KAAC had addressed a letter dated 13/3/2024 to the petitioner, purportedly furnishing the information sought for by the petitioner in his RTI application. The contents of which read as under page 32, B to P. Para on receipt of the number to on receipt of on receipt of the letter dated 13/3/2024 from the principal secretary in charge, Karmi KAAC, right, letter dated 13/3/2024. I got a question here. The petitioner approached the commission once again by submitting a letter, by submitting a complaint on 21/5/2024, stating the fact that he had received an email on 13/3/2024 and subsequently, the information via and subsequently, the information by post from the SPIO O/O, the principal secretary, KAAC, post up. In his complaint, the petitioner had alleged that though some information was supplied to him, but he found the information supplied to him to be misleading and unrelated to his RTA application dated 6/10/2024. Post up. Along with his complaint, the petitioner submitted the photocopies of the information received by him on 13/3/2024 from the SPIO as Annexer Roman 3 to the said complaint. Post up. With the aforesaid projections, the petitioner requested the commission to take necessary action against the Principal Secretary in charge SPIO post-stroke Principal Secretary in charge Karbi Anglong Autonomous Council and Roman and SPIO post-stroke Principal Secretary KSC under the right to information under the RTI Act for supplying wrong and misleading information and for willful disobedience and deliberate disrespect of the order dated 6/3/2024 of the Commission passed in the second appeal, case numbers 330423 stroke KAN bracket close stroke 4 stroke 2023. Post up. Para. As the petitioner has preferred this petition, contending that despite receipt of the complaint dated 21/5/2024 by the Commission, on 31/5/2024, there was no consideration on the complaint and hence the repetition under Article 226 of the Constitution of India. Post up. Heard Mr. B. Kishan, learned counsel for the petitioner. Is Forrest there? Mr. B.D. Deka.
Lordship, D deck.
B. Deka.
D
D. Deka, learned standing counsel, Assam Information Commission for the respondent number 2 and Mr. J. Sutia, learned standing counsel, Karbi Anglong Autonomous Council for the respondent number 3 and 4. Post up. Para.
3 and 4.
Yes. Mr. Shen, learned counsel for the petitioner, has submitted that the commission is a statutory commission under the RTI Act. Post up. In the case in hand, the commission entertained a second appeal and thereafter disposed of the second appeal by an order dated 2024, directing the SPIO to furnish the information to the petitioner via email stroke registered post without fail. Post of. Such a direction came to be passed when, during the hearing held before the Commission on 5/3/2024, the SPIO and the Learned Standing Council KAAC had made a prayer before the Commission that the information under the RTI Act would be supplied to the petitioner provided they were granted 10 days time. First, he has further submitted that in the complaint dated 21/5/2024, the petitioner had categorically contended that the information supplied to him by the letter dated 13/3/2024 were misleading and not related to his RTA application dated 6/10/2024. Full stop. In order to substantiate such contention, the petitioner had also furnished the photocopies of the information he had received on 13/3/2024 from the SPIO. Post of. When a request has been made to take necessary action for supplying wrong and misleading information and for willful disobedience and deliberate disrespect of the direction passed in the order dated 6/3/2024, the Commission should have acted under the provisions, should have treated the complaint under Section 18 of the RTI Act, and thereafter should have proceeded to make an inquiry about the contentions made by the petitioner in his complaint dated 21/5/2024. Post. Yes, your judgment. Paragraph
10, Lordship.
starts with word
Paragraph 10, Lordship.
10,
Nature of the section.
manner of power. Then
What my contention is, before your Lordship, is that section 18 being the nature of section 18 being supervisory, will it be permissible in law to apply it for executing an order of the commission lords? That probably has to be.
What is supervisory? It can be related to Article 227.
Lords,
That is also supervisory jurisdiction. When the courts under it
Lords,
or the tribunals under it
Lords,
does not act as per the provisions, then it can make any direction as permissible. And
Lord.
one of the thing is that when a jurisdiction is vested in a court or tribunal or an authority,
Yes.
the other one, the Mandamus also, when a jurisdiction is vested or discretion is vested in a court, tribunal or authority, and that authority does not exercise that jurisdiction, then a citizen has a right or a person has a right to file a complaint. It has to come to a reasonable conclusion. It does not exercise its discretion. It has to exercise the discretion, either reject or that. But supervisory jurisdiction is that.
Lordship, that is in an original application when RTA is not
Okay.
information. That is what has been the.
Where it is said, mister, where you are trying to distinguish and trying to make the commission as a toothless one.
Lordship, that is the.
That is not, nowhere it is said,
There is no judgment.
none of the decisions.
Lordship,
Show me that 18 is completely barred and it should be treated as redundant if your submission is correct. Show me something.
What I'm submitting is once an order has been passed under section 19(3), can we route back to section 18 as in complaint, Lordship? That is the.
This is I am holding.
Lordship.
A number of high courts are holding.
We will oblige.
In fact, I am told that coordinate benches are holding.
Will be obliged if that order comes.
I think you are the counsel, you would know.
We haven't come across as maybe it's my.
Mr. Deka, Learned Standing Counsel, Assam Information Commission has submitted that the powers of the commission under section 19, under section 18, and under section 19 of the RTI Act are distinct and separate, distinct. Full stop. The power under section 19 is an appellate power, whereas the power of the commission under section 18 is a supervisory one.
Lordship.
Right?
That is what. Lordship.
That is one.
That is what.
You are
it is.
saying,
Yes, Lordship, that is.
full stop. What more? That it is barred.
Lordship, I'm saying, after order is disposed of by under section 19(3) in a second appeal, if that is not complied with the department, can that a complaint of non-compliance be treated under section 18?
So what will happen? Tell me.
Lordship, what?
Tell me the route thereafter.
Lordship, on the.
You
even
tell
on
me the route also.
Even on the last occasion, Lordship, the basis of we are not acting on non-compliance was that understanding of the commission and commission was that. However, Lordship, if you look in the other side,
Not tell me the route.
Lordship,
Tell me the route. Which one is will be the route?
my humble submission, Lordship,
226 or 227?
Lordship, 226 will give a legal right is created on to the petitioner by the order, as he has no alternative and efficacious remedy. So, Lordship, in my humble submission, 226 he has to come, otherwise he will not have an
And
alternative.
High Court will assume the executing court's jurisdiction.
That is.
Tell me that in that line.
Lordship, not.
I am
Lordship,
wanting your submission.
I'm not submitting on that line, Lordship.
226 what will do? What the court will do? Tell me.
Will-
Tell me. If your submission is that I'll direct the State Information Commission, KAAC, PIO to furnish the information, that will be a role of the executing court. Now, what is Mandamus and what is Statutory? Statutory simply quashes the order and it does not
Pass it directly.
pass further order. directs the authority to revisit the order, certiorari. Here, it is not a case of certiorari. You have passed the order and they are alleging inaction. Now, then whether mandamus is what? When a citizen has a right and the tribunal, court or authority, if it is civil court, it is a different. A tribe or any authority under Article 12 or a public authority or a tribunal owes a duty. Now, see the wording of Section 18 once again. See the word. What the word?
Powers and function of the Information Commission.
Yes. Read further.
Subject to the provisions of this act, it shall be duty.
Duty.
Yes, Lord.
Duty.
Subject to the provisions. Of
Where is your duty? Sitting in action is your duty.
Lordship, it is in my humble submission, it will not be in
So
action.
tell me what is your exact submission. I will record because appellate jurisdiction is supervisory jurisdiction.
Lordship,
Then after an appeal is appellate's order in the second appeal is filed. Now,
Yes.
what is the duty of the commission on receipt of a complaint? That is, I will record.
Receive the complaint of non-compliance of the order of the commission.
Okay.
That order we are clutched because there is no provision which permits us to act on it.
Okay. Mr. Deka has further submitted that after an appeal order in a second appeal preferred under Section 19 of the RTA Act is passed by the commission, and disposes of the second appeal. The petitioner, the commission, has no power
No power as per.
to take cognizance of a complaint of such nature under Section 18 of the RTA Act. This
Of
is your submission
non-compliance.
in support of his submissions, Mr. Deka has referred to the decisions of the Honorable Supreme Court in Chief Information Commission and another versus State of Manipur and another, 2011-15 SCC 1 and 2023-14 SCR. Kishan Sanjain versus Union of India and others, 2023-14 SCR 477:223 INSC 915. Or it SCC लिखा है नहीं? SCC लिखा नहीं ना? Okay. Yes, your regulation. Mr. Sutia, Learned Standing Council, KAAC, appearing for the respondent number 3 and 4, who are the SPIO in the case in hand, has submitted that.
Under Section 6(3) of the RTI Act, my lord, the application submitted by the petitioner was forwarded to the.
Okay. The application submitted by the petitioner under Section 6 of the RTA Act was forwarded to the appropriate authority under Section 6, under subsection 3 of Section 6 of the RTI Act. Where is that?
It is the page 32 to the Chief Conservator of Forest, Council Head of Department Forest, Karbi Anglong Autonomous Council.
with any information to the applicant.
No, so it is for the petitioner that.
No.
My lord.
You are forwarding. Let us see the provision.
My lord.
Let us see the
My-
provision,
my-
Mr.
My lord.
Established from record. 60 is what? And inform the
For an
applicant
application
immediately
is
about
made
such
with public
transfer.
authority requesting for an information which is held by another public authority, the subject matter of which is more closely connected with the functions of another public authority. The public authority to which such application is made shall transfer the application or such part as it may appropriate to that particular authority.
And read further. The public authority to which such application is made shall transfer the application or such part
Inform
of
the
so and so
applicant-
and inform the applicant immediately about the transfer. Where is that? Where is that?
My lord, petitioner admitted that that application was mailed to the petitioner.
Which one?
That application, that, my lord,
Where is admission? Where is the admission?
My lord, that is, my lord, annexer 10, page 32.
Hmm.
Petitioner received it. It is addressed to the petitioner, my lord.
Received your petition.
My lord, it is
Dated,
addressed to
you are replying in 2024
my lord,
that received your petition on 20/04/2022
my lord.
and it was forwarded to the chief information conservator dated 85 for
18/5/2022.
submission of his views and comment in this regard. Copy
Madam.
and close.
Madam.
60 contemplates after reply inform about in 2024.
My lord, that is what is record.
Complete.
My lord, my lord,
Absolutely.
my lord. Whether it is, my lord, misleading, wrong, it is required to be decided by. the
That
state
I'm
court.
not commenting, Mr. Sutia. I'm not commenting on it.
My lord.
Misleading or this thing.
Or it is
I'm not
inadequate, or it is
Mr.
inadequate,
Sutia, I'm
My
not
lord.
complaining about anything.
my lord. But
That
lordship
I'll
observed-
not record.
But lordship observed that.
No, I'll not observe.
But-
I
No.
have made it clear. What he had alleged in the complaint, I have noted.
But-
I have not given my views,
My lord,
Mr.
my lord,
Sutia.
My lord, it is- my lord.
I am only on
I
the
understand.
power under Section 18.
My lord, my lord.
And it has to be, if I hold that this is a complaint under Section 18,
My lord.
that inquiry has to be done by the commission and it has to reach its own decision.
My lord, my lord. I have,
I am not commenting on it.
so only my submission is that.
My
lord, my lord.
my
My lord,
there is the ambit of
my lord.
I read in the nature of Mandamus is also limited.
My lord, whatever is in the record, my lord, I am submitting only on the basis
Okay,
that it was, my lord,
has submitted that.
it was communicated to the.
Has
petitioner.
submitted that after receipt of the original application of the petitioner
And
on
submitted, my lord.
24. This is 24.
One original application submitted to the chief executive member, that is the political head. So that is the important part, my lord, on our part. The application, he sought the application information about his application submitted to the political head of the council, my lord. not to the
Mr. Sutia,
No, only
Mr.
my lord,
No,
chief
Mr.
executive member.
Sutia, come to page 20.
Yes,
20. He was not concerned with that 20/04/2022.
my lord,
We are concerned with 6/10/2022.
my lord, my lord.
Am I making it clear?
My lord, my lord.
He said that he approached earlier to these authorities, but he started taking steps under the RTA Act from page 20 onwards. Where is that?
He has submitted, my lord, he sought the information about his application to the chief executive member. So that is the, my lord, that is, he submitted the application.
Come to page 21.
21, my lord.
Why you are trying to?
No, it is admitted, my lord, page, my lord, paragraph 1.
He
my
is
lord.
very clear about it.
Yes, my lord.
He is very clear about it.
No, it is.
I am not. If you want to make it longer,
No, only lordship addressed that the application submitted to the chief executive member. That word is there, my lord. If you may put that word only. When the
now
chief-
I'll hold adversely.
Lordship,
Hold adversely. If I'm not
no,
taking,
lordship,
I'm
yes,
taking,
yes,
not taking note of page 18,
my lord.
then it is
page
going to be bad on you. I'm not taking note of this page 18.
The page not 21, my lord, page 21.
Page 21 is public information officer.
No, page 21, my lord, second paragraph. Second, what is the case, my lord, contention? When did the said petition place in files before the honorable chief executive member? When did a petition receive in the office of the chief executive member? That is his contention. My lord. So I'm putting it that the chief executive member, he has submitted. So that is his petition. So we have.
I'm not commenting, Mr.
Yes, my lord.
Mr. I'm not commenting about the questions
Yes,
and
my
the
lord.
reply.
Yes, my lord. My lord. My lord.
Why you're
My lord.
unnecessarily taking
Yes,
me
my
to
lord.
that?
My lord. That is my
I'm
first
not
contention.
understanding actually.
My lord. That is my first contention. But as your lordships, my lord, that it is the regarding the legal provisions, my lord.
No, I am on the that appearance of the chief executive, sorry, principal secretary before the commission and the standing council,
My lord.
and they are under to supply whatever
Whatever, my
they
lord.
submitted to the jurisdiction of the tribunal commission.
Commissioner.
We are not into question number 1 and reply to question number 1.
So our contention.
We are not dealing. If you want to deal me, I'll deal.
No, my lord, only my contention.
I'll deal then.
No, my lord, my contention is that
Despite my repeated,
only na PS 32 that it was
I
communicated.
try to assuage you that I am not dealing with it.
Yes, my lord.
But still you are
I'm
insisting,
insisting.
then I'll hold it.
I'm not insisting. Then my second point is, my lord.
Yes,
Lordship,
please, on law.
Section 19(8).
Okay, no, on law you can say.
RTI Act, my lord.
We are
RTI
not dealing with it.
RTI Act, Section 19(8). As the petitioner submitted his application under Section 19.
We are not concerned with these political masters.
Section 19.
Why
my
still
lord.
you are still going for political masters?
My lord. He filed the application, my lord, not us, my lord. So, my lord, Section 19(8), 8, my lord, subsection 8, and C, my lord. In the first 7, the decision of the State Information Commission, as the case may be, shall be binding. So there is a procedure for imposing penalty under Section 19(8)(c).
19(8)
C.
C.
Impose any of the penalties provided under this Act. So Section 20 is the provision for imposing the penalty. So the my submission, my lord, the State Information Commission is required to proceed if the information is inadequate, wrong, or misleading, then for imposing the penalty, not for giving the information, my lord. That has been held by the Honorable Supreme Court in that particular case, my lord, 2011 15 SCC 1. In that case, my lord, paragraph 32, my lord. That is the, my lord. I'm reading it, paragraph 32.
It starts with
In the facts, my lord. Now, it has been contended. Paragraph 31. 31, my lord. It has been
you are holding SCC.
SCC, my lord.
He has handed me over something else. 31. In 31. Okay.
Okay, page 30 then. Yeah.
No, the
paragraph
paragraph starts
30.
with. Paragraph starts with.
It has been contended.
Okay.
It has been contended before us by the respondent that under Section 18 of the Act, the State Information Commission has no power to provide access to information which has been requested by any person, but which has been denied to him. The only order which can be passed by the Central Information Commission or the State Information Commission, as the case may be, under section is an order of penalty provided under Section 20. However, before such order is passed, the commission must be satisfied that the conduct of the information officer was not bona fide. The second, paragraph 32, we uphold the said contention and do not find any error in the impugned judgment of the High Court, whereby it has been held that the commissioner, while entertaining a complaint under Section 18 of the said Act, has no jurisdiction to pass an order providing for access to the information. So that is the distinctions made by the Supreme Court regarding 18 and 19, my lord.
Okay.
My lord, then the paragraph 42. And here, my lord, 41, my lord. No, not 41, my lord. 42. We are of the view that paragraph 37, my lord. Yeah, in the particular. We are of the view that section 18 and 19 of the Act serve to different purposes and lay down to different procedures, and they provide to different remedies. One cannot be substantiated for the other.
Has submitted that in
2011, 15 SCC
in
1.
Chief Information Commissioner and Supra
First one, look into it.
2011-15 SCC 1.
One. Verse
It
8.
has been clearly held that the section 18 and section 19 of the RTI Act serve two different purposes. And it has been laid down, it has laid and have laid down two different procedures providing to different remedies. And first of it has been further held that one cannot be a substitute for the other. First of, and as such, first of, he has thus contended that the submission of a complaint of the nature which the petitioner has filed in the case in hand before the commission on 21/5/2024 is not an appropriate remedy.
It's not
The
an
remedy,
appropriate
about remedy
application.
now.
It's not an appropriate
It
application.
is further submitted that the section subsection 8 under subsection 8 of section 19 of the RTI Act has vested the commission with the power to impose penalty under section 20. Full stop. About the remedy?
My lord, remedy, lord.
Now nobody is submitting
My
about the
lord,
remedy.
my lord, remedy, my lord, lordship.
If the submission, I will hold.
My lord,
If the submission,
my submission, my lord.
counsel for the respondents are to be accepted.
For assisting the court, my lord, my submission is that for imposing penalty, my lord, the commission is required to
And
make an inquiry.
both of you are submitting
No,
that
both
this
of-
petition is not maintainable?
No, now my submission is that maintainable in the present form.
Hmm?
Maintainable in the present form.
He has further contended that the instant present petition is not maintainable in the present form.
Not repetition, but an application submitted before the commission.
Okay. And a complaint dated 21/5/2024 submitted before the commission is not maintainable in the present form. Full stop.
My lord, only to assist the court, my lord, that is by submission, my lord. As there is a provision for imposing penalty under section 19(8)(c), so that it is required to make an inquiry. To make an inquiry, the provision is under section 18, my lord.
He has further submitted that in order to impose penalty under
Section 19
subsection 8 of section 19
and section 20
by a procedure of inquiry.
is required to be made.
An inquiry is to be conducted by the commission, and it is for the said purpose.
Only
The provisions of section 18
can be
can be applied.
when he gets submission.
Full stop.
Can be invoked by.
Full stop.
May I not take 2 minutes of your lordship?
I have heard you enough.
I'll just refer to section 18 just once.
We have read enough and enough. How much? This is a read petition, so you will have the remedy of taking it to higher court.
Actually, we are not averse to information being accessed.
But you are not providing anything.
That-
So if I'll hold, if the submission of the learned counsel for the respondents are to be accepted, the petitioner will be denied of the fundamental right of under Article 219 1A.
That's-
I'll hold now.
that's-
Okay. I have considered the submissions of the learned counsel for the parties, and I've gone through the decisions referred to by the learned counsel for the respondents. Close to. As the submissions of the learned counsel for the parties and to decide the issue. The কি করলো? Involved in this repetition, it would be appropriate to refer to the provisions contained in section. It would be appropriate. It পিছত লিখিব। এইটো পিছত লিখিব। First লিখক। The Right to Information Act has been enacted. For setting out a regime of right to information for citizens to secure access to information under the control of the public authorities, in order to promote transparency and accountability in the working of every public authority. Under Section 3 of the RT Act, has provided the right to information to all the citizens, subject to the provisions contained therein. Section 2J has prescribed, provided the definition, has defined, as per Section 2J, quote unquote, a right to information means so and so. Public authority, as per Section 2H, means so and so. Obligation to provide information is cast under Section 4, obligation is cast on every public authority to provide information. To maintain its records and to facilitate right to information under the RTI Act. Full stop. It has been made mandatory by the provisions of Section 5 to appoint Central Public Information Officer or State Public Information Officer, as the case may be, in all administrative units or offices. Full stop. A person as per section of 6, a person who desires to obtain any information under the RTA Act, can make a request in writing or through electronic means. Accompanying such fee as may be prescribed. Specifying the particulars of the information sought by him or her before the concerned public information officer. Full stop. Subsection 3 of section 6 has provided that where an application is made to a public authority requesting for an information, Roman 1, small, which is held by another public authority, semicolon, or Roman 2, the subject matter of which is more closely connected with the public authority, to which such application is made, shall transfer the application or such part of it as may be appropriate to that other authority and inform the applicant immediately about such transfer. Full stop. Section 7.
Yes, secret lord comes. Yes, secret lord comes.
After a request for information is made, the primary obligation of consideration of the request is of the public information officer as provided in section 7. Post of such request has to be disposed of as expeditiously as possible. Post of. In any case, within 30 days from the date of receipt of the request. Also, full stop. In any case, either the information shall be provided or the same may be rejected for any of the regions provided under section 8 or section 9. Post of the proviso to section 7 has made it incumbent that when it concerns the life or liberty of a person, subsection 2 of section 7 has prescribed that if the concerned public information officer fails to give the information specified within a period of 30 days, it shall be deemed that such request has been rejected. Full stop. Subsection 3. Subsection 8 of section 7 has mentioned that whereas so and so, Section 8 and section 9 have enumerated the grounds of exemption from disclosure of information and also grounds for rejection of request in respect of some items of information respectively. Section 11 deals with third-party information. First stop. Section 12 has provided for constitution of Central Information Commission and section 15 as provided for Constitution of the State Information Commission. Full stop. The powers, Chapter 5. The statutory provisions contained in Sector 5 of the RTA Act has provided about the powers and functions of the Information Commission, appeal and penalties. Full stop. As the provisions of Section 18, Section 19 and Section 20 have been referred to and are involved in the case in hand, the said provisions are quoted herein below, in its entirety. I'll come back. Section 18 of the Act, subject to the provisions of the Act, has provided that it shall be the duty of the Central Information Commission or State Information Commission, as the case may be, to receive and inquire into complaints from any person. It appears that the powers under Section 18 of the Act have been categorized under Clause A to Clause F of Section 18(1). So under Clause A to F of Section 18(1) of the Act, the Central Information Commission or the State Information Commission, as the case may be, may receive and inquire into complaints of any person who has been refused access to any information requested under the Act, Section 18(1)(b), or has not been given, has been given incomplete, misleading or false information under the Act Section 18(1)(e), or has not been given a response to a request for information or access to information within the time limit specified under the Act Section 18(1)(c). Full stop. In the case in hand, the petitioner as the applicant first appellant second appellant in his complaint dated 21/5/2024 has made a contention that the information supplied to him pursuant to the order dated 6/3/2024 of the Commission, were misleading and not related, misleading and wrong, and were not related to his RTI application Full stop. Under section 18(3). Of the Act, the Central Information Commission or the State Information Commission as the case may be, while inquiring into any matter under section 18(1), have been vested, has been vested with a power, with the same powers as are vested in a civil court while trying a suit under the Code of Civil Procedure, in respect of the following matters, namely A, B, C, D, E, F. CPC consent. Thus, the summoning and attendance of the witnesses is dealt with in section 30, section 31, and section 32 of the CPC, which reads as under. The detailed procedure for summoning and attendance of witnesses is dealt in order Roman 16 of the CPC, rules 1, 5, 1, 5, 6, 7, 10, 14, 15, 18, and 20 deal with summoning of witnesses to produce documents. For the sake of brevity, the said provisions are not quoted herein. Full stop. Subsection 4 of section 18. এই ভারত ফোর্স টু লক্ষণ ভারত ফোর্স বলে একটা আছে ইউনিয়ন অফ ইন্ডিয়া জিএসটি কেস of the act is with a non-obstante clause, and it has given overriding power. It has provided overriding powers to the state Central Information Commission or the State Information Commission, as the case may be, to examine any record by laying down, by examining any record during the inquiry of any complaint under the Act, examine any record to which the Act applies, which is under the control of the public authority, and no such record may be withheld from it on any ground. Full stop. Para. If the in the judgment it is true that in Kisan Jain Supra, it has been held that it has been observed that which paragraph, Mr. Deka?
Lordship, 30,
Supervisory.
supervisory will be Lordship. 20, Lordship, that would be 34.
34.
Goes on to the next page,
34.
which is upheld by the
Starts with
section 19.4 deals with the procedure relating.
19.
Section 19.4 deals with procedure relating to information of a third party. 19.5.
No, where it is supervisory, some.
That is in the next page, the procedure for hearing.
Huh?
Lordship, that will be paragraph 35.
30.
Step 35.
35.
Procedure for hearing the appeals have been framed in exercise of power under clause.
35. In Kisan Chan
Yes, Lord.
or in the CIC
In CIC versus
Manipur,
Manipur. And Kishan is 10 paragraph.
paragraph 10. Okay.
That is upholding paragraph
Okay.
35.
In the Central Information Commission, Supra. In cell, and it is true, it has been observed in Central Information Commission, Supra, that section 19 and section 18 and section 19 serve two different purposes and lay down two different procedures, and they provide two different remedies, and one cannot be a substitute for the other. Full stop. Where is the supervisory one?
35, Lordship. Line of
35.
the procedure for hearing the appeals have been framed in exercise of power under clause E and F of subsection 2 of section 27.
It has been observed that the procedure contemplated under section 19 and section 18 and section 19 is substantially different. Full stop. The nature of power under section 18 is supervisory in character, whereas the procedure under section 19 is an appellate procedure, and the person who is aggrieved by refusal in receiving the information which he has sought for can only seek redress in a manner provided in the statute, namely, by following the procedure under section 19. First, para. In CIC, Central Information Commission, Manipur, the facts, the backdrop of events can be noticed as follows. The applicant therein filed an application on 9/2/2007 under Section 6 for obtaining information from the State Information Commission relating to magisterial inquiries initiated by the government of Manipur from 1980-2006. As the application under Section 6 received no response, the applicant filed a complaint under Section 18 before the State Chief Information Commissioner, who by an order dated 30/05/2007 directed the public authority to furnish information within 15 days. The same applicant filed another application on 19/5/2007 for obtaining similar information for the period between 1980 March 2007. As no response was received that time also, the applicant filed a complaint again under Section 18, and the same was disposed of by an order dated 14/8/2007, directing disclosure of the information sought for within 15 days. Of the State Chief Information Commissioner were challenged by two writ petitions. Both the writ petitions were heard together and were dismissed by a common order dated 16/11/2007. Entirely upholding the order of the Commissioner, State Chief Information Commissioner, a writ appeal came to be filed against both the judgments and the division bench disposed of the writ appeal by the impugn order dated 29/7/2010. By the impugn order, the Honorable High Court held that under Section 18 of the Act, the State Chief Information Commissioner had no power to direct the respondent to furnish the information, and further held that such a power had already been conferred under Section 19(8) of the Act on the basis of an exercise under Section 19 only. The division bench further came to hold that the direction to furnish information was without jurisdiction and directed the commissioner to dispose of the complaints in accordance with law. When the matter reached the Supreme Court, the Honorable Supreme Court, it was contended when the matter reached when the matter when an appeal was preferred against the judgment of the division bench of the Honorable High Court, it was contended before the Honorable Supreme Court that under Section 18 of the Act, the Central Information Commission or the State Information Commission has no power to provide access to information which has been requested for by any person, but which has been denied to him. Full stop. The only order which can be passed by the Central Information Commission or the State Information Commission, as the case may be, under Section 18 is an order or penalty provided under Section 20. Full stop. It has, however, been held that before such order is passed, the commissioner must be satisfied that the conduct of the information officer was not bona fide. Full stop. The said contention was upheld by the Honorable Supreme Court, finding no error in the impugned judgment of the High Court, whereby it was held that the commissioner, while entertaining a complaint under Section 18, had no jurisdiction to pass an order for providing for access to the information. Full stop. For the purpose of dealing with the issue, the Honorable Supreme Court had taken note of the facts of the case and after considering the provisions of Section 18 and 19, including Section 19(8), has gone on to observe, as mentioned above, that the procedure contemplated under Section 18 and Section 19 is substantially different. Full stop. In order to also, it has referred to the settled proposition that when a procedure is laid down statutorily and when a procedure is laid down, where a statute provides for something to be done in a particular manner, it can be done in that manner alone, and all other modes of performance are necessarily forbidden. Full stop. If it transfers, it appears that such an observation regarding such an observation not to end, it is necessary to mention that the applicant therein, after not receiving any response in his application, in his application under Section 6, the applicant had directly approached the chief state chief information commissioner directly under Section 18 without pursuing his remedy of first appeal and second appeal under first appeal under
Section 19(1).
18(1),
19(1).
19(1) and 19(3)
3 is the second.
of the Act. Full stop. And it has, it is in the light of such facts, it has been held that if the contention of the if the contention regarding such procedure is to be accepted, then section 19 would become unworkable, and specially, section 19(8) will be rendered as surpluses. Full stop. It has been held that such an interpretation would be totally opposed to the fundamental canons of construction. The Honorable Supreme Court has gone on to observe as under section para 42 CC2 devotion SCC 2011-15 SCC 1. (42) लिखिब and 43 लिखिब. The Honorable Supreme Court has further taken note of the direction given by the division bench in the penultimate paragraph of the impugned judgment and order, whereby the division bench had directed the Information Commissioner, Chief Zituasa, to dispose of the complaints of the applicant in accordance with law. Full stop. Taking note of the said direction, the Honorable Supreme Court had directed the appellants to file appeal under Section 19 of the RTI Act in respect of the two requests made by them for obtaining information by the applications dated 9/2/2007 and 19/5/2007 within a period of 4 weeks. With the observation that if such an appeal is preferred following the statutory procedure by the applicants, the same should be considered on merits by the appellate authority without insisting on the period of limitation. Full stop. Insofar as regards the direction made the last concluding direction was set aside from the silometer. We say upon idea. Yeah. Last part of the direction was set aside.
Okay.
That division bench directed the commissioner to dispose of. After setting aside,
Very good.
it made a contradictory direction. That was set aside.
However, the observation which says is the distinctive nature of that is the.
We will
observation.
do that.
Okay.
We'll do that. I am conscious of the fact. The petitioner in Kishan Jain approached the Honorable Supreme Court under Article 32 of the Constitution seeking direction for the better functioning of the State Information Commissions under the Right to Information Act 2005. Post up. The Honorable Supreme Court after taking note of the provisions, powers and functions of the Information Commission under Section 18 and the appellate powers under Section 19, which allows any person aggrieved by refusal of information to seek an effective redress and remedy. Has gone on to observe that the State Information Commissions exercise broad powers, including among them the powers to conduct inquiries into complaints from any person, hear appeals and impose penalties. Full stop. It has been observed that the State Information Commissions decide on matters and issues pertaining to the right to information, and the Information Commissions are required to act in a fair and just manner while following the procedure laid down in Section 18, Section 19, and Section 20 of the Act. Post up. Para. It is settled. It is too settled that it is too settled, as also held in CIC, Supra, and Kishan Jain Supra, that the right to information is not merely a statutory right for. Please take your seat. Why you are standing?
May I come in, Milord, one point? Milord, what my learned friend has, Milord, relied upon the judgment, Milord, your lordship has indicated. Milord, in that case, Milord, directly applicable.
I have already recorded. Why you are repeating?
My lord. It was.
Are you not hearing my dictation? Huh? Then why you are repeating then?
They directly.
Have I not dictated about that?
We have
Under 6, then direct 18. That is what I had not dictated. Then why you are interfering?
We have exhausted.
Please don't disturb the thought process. I have already recorded without any kind of submission from your side.
All right.
Right to information is not merely a statutory right, and it has and it is a constitutional right. Post up. The RT Act is based on the principle that citizens have a right to know about the functioning of every public authority, and it places a duty on the public authorities to act in a responsible and transparent manner by providing information about their functioning to the citizens. Post up. It has been held that the freedom of speech and expression under Article 19(1)(a) includes the right to acquire and disseminate information. Full stop. The right The right to information has also been recognized as a facet under Article 21. Full stop. The in Kishan San Jain Supra, it has been held that the such a right to information entails a heightened burden and responsibility of on the state Central Information Commission and the state information commissions to ensure that the individuals get access to information on matters of public concern under the provisions of the RTI Act. Full stop. The Constitution bans in Onita Kushwara versus Sonadhan, 2016, 8 SSC 509 has held that access to justice is a right of Constitution. Access to justice is a facet of Article 21 of the Constitution of India. Full stop. Para. If the submission of the Learned Council, Standing Council, State Information Commission is to be accepted, that the jurisdiction of the State Information Commission under Section 18 being only supervisory in nature, has not vested the State Information Commission to inquire into a complaint of an applicant falling within the purview of any of the clauses from A to F. A to F?
Lordships,
A to F. Huh?
the complaint which is filed after the non-compliance.
After A to F of subsection 18 or subsection 8 of section 18 is to be accepted, then with no power on the with no power vesting in the State Information Commission under section 19 of the Act to enforce compliance of its order, the provisions under section 18 of the Act providing the powers to the State Commission to inquire into a complaint of any person, bold, falling within the purview of subsection 1 of section 18 would be rendered odious and superfluous and unworkable. Full stop. The Honorable Supreme Court in CIC's Manipur has already held that an applicant, after submission of an application under section 6, could not have approached the State Information Commission under section 18 directly, alleging refusal of information to him by the public authority. So directly, and what kind of complaint will be entertained then?
Lordship,
What kind of? Supreme Court has CIC held that after Section 6, you cannot come directly 18.
only with regard to getting a direction to access the information.
Hmm?
Only under section 18, if
Now,
under,
why then A to F, Mr. Counsel?
Lordship, can
Anyway,
you take up
okay,
section 18?
I have.
And
Okay. Probably. If after an applicant if an applicant after preferring an application Section 6 and thereafter preferring a first appeal under Section 19(1) and a second appeal under Section 19(3) of the Act, still does not receive the information he has sought for, and in such situation, he is to be prevented to file an application under any of the sub-clauses from A to F for Himalayas asylum under Section 18, then such an application would be left remedialess to receive remedialess to receive the information he has sought for, and the same will be, and same cannot be, and same does not go together with the his fundamental right of access to information under Article 19(1). A of the Constitution of India. Full stop. Para. The by the the State Central Information Commission or the State Information Commissions by holding that the power of the Central Information Commission or the State Information Commissions under Section 18 are supervisory in character, this court is of the considered view. Sorry. Sorry. It has been settled that so and so have supervisory jurisdiction under Article 18, Section 18. And the same goes to mean that the Central Information Commission or the State Information Commissions have the power, authority, and jurisdiction to pass necessary orders to keep the public authorities over whom it exercises jurisdiction within its bounds and can enforce compliance of the provisions of the right to information to the applicants. Full stop. Para. The State Central Information Commission and the State Information Commissions are statutory authorities established under Section 12 and Section 15 of the RTI Act. Full stop. The powers and functions of these information commissions are well delineated in Section 18, already quoted here in above. Full stop. In Section 18, it has been, the legislature has incorporated that it shall be the duty of these commissions to receive and inquire into a complaint from any person on any of the issues covered by A to F of subsection Section 18 to full stop. Para. Add this, comma, it would be appropriate to refer to the scope of a writ in the nature of Mandamus. Full stop. It is settled that a writ in the nature of Mandamus would lie when a statute imposes a duty and there is failure in discharge of duty. Full stop. It is also well settled that the High Court, no, the High Courts, it has been well settled that the jurisdiction under the jurisdiction, sorry, Article 226 of the Constitution of India. So, sorry, this court's jurisdiction. Now, while exercising jurisdiction under Article 226 of the Constitution of India, this court has the power to issue a writ of Mandamus or a writ in the nature of Mandamus, or to pass orders and give necessary directions where the government or a public authority or a statutory authority has failed to exercise or has wrongly exercised a discretion conferred upon it by a statute or a rule or a policy decision of the government, or has exercised such discretion mala fide or on irrelevant considerations, or by ignoring the relevant considerations and materials, or in such manner as to frustrate the object of conferring such discretion or the policy for implementing which such discretion has been conferred. So in all such cases, and in all other fit and proper case, a high court can, in the exercise of its jurisdiction under Article 226, issue a writ of Mandamus or a writ in the nature of Mandamus, or pass orders and give directions to compel the performance in a proper and lawful manner of the discretion conferred upon the statutory authority or the public authority, and in a proper case, in order to prevent injustice resulting to the concerned parties, the court may itself pass an order or give directions which the public authority or the statutory authority should have passed or given had it properly and lawfully exercised its discretion. 1986 2 SCC 679. In Andi Mukta Sadguru, Sri Muktaji Bandas Swami Subarno Jayanti so 1989 2 SCC 691. The Honorable Supreme Court has held that the para 20 while dealing with the word authority used in Article 226 of the Constitution of India, and also dealing with the issue as to whether a writ of Mandamus or a writ in the nature of Mandamus will lie even if the duty is not imposed under a statute, has held as follows: para 20. Full stop. In when it is also settled in so and so asset reconstruction. Oh no, sorry. After considering a number of precedents, the Honorable Supreme Court on the scope of Mandamus or scope of a writ of Mandamus, the Honorable Supreme Court in Union of India and others versus Bharat Forge and another 2022-17 SSC 188 has held that a writ of Mandamus or a direction, in the nature of a writ of Mandamus is not to be withheld, in the exercise of powers of Article 226 on any technicalities, full stop. This is subject only to the indispensable requirements being fulfilled, full stop. There must be a public duty, full stop. While the duty may arise from a statute ordinarily, the duty can be imposed by common charter, common law, custom, or even contract. So the fact that a duty may have to be unraveled and the mist around it cleared before its shape is unfolded may not relieve the court of its duty to call out a public duty in a statute or otherwise, if in substance it exists. Equally, a mandamus will lie if the authority, which at a discretion fails to exercise it and prefers to exercise it. Full stop. A writ of mandamus or a direction in the nature thereof has been given a very wide scope in the conditions prevailing. Has given a wide scope, and it is to be issued wherever there is a public duty or a statutory duty and there is a failure to perform, and the courts will not be bound by technicalities, and its chief concern should be to reach justice to be wrong. Full stop. Para. The phrase, quote unquote, any person, appearing in section 18 is not defined anywhere in the Act. Full stop. As the phrase, any person appearing in section 18 is without any restriction, the same would include an applicant also who approaches the commission after being with a contention that after exhausting the procedure outlined in section 6, section 19.1 and section 19.3 of the Act, that with the approaches that so and so, with a complaint that the information supplied to him were either misleading or not related to, or misleading or wrong. And there was willful disobedience and deliberate non-compliance of the direction given by the commission under section 19.3 in a second appeal under section 9, preferred under section 19.3 of the Act. We'll deal with, come back.
Yes, Lordship.
Yes, anything?
Lordship, only one point. Under section 18, if we deal with a complaint of non-compliance, we still clutch not to pass an order to access the information as per the order of the Supreme Court. We can only penalize. So if the fundamental rights of the petitioner.
I'm trying to distinguish. That is not
Lordship,
the appropriate. I'm holding you have a right to appeal.
No, I'm just
You have a
saying,
right to.
we cannot
I'm
even
saying
give
that.
access to the information. We'll only can penalize.
You can, that is why I have quoted section 30, 31, 32, and order 16 of the CPC. Knowing that this would come from your side.
Like,
Suryodev Rai. 2003, 6 SSC. 2003, 6 SSC. 675. Last time কোনটো আছিল? Applicant. Huh? Applicant. When a statutory authority is vested with a jurisdiction which is supervisory in character. Supervisory in character. Comma is exercisable. Such supervisory jurisdiction is exercisable when any of the authority over whom it exercises jurisdiction, comma, it exercises such supervisory jurisdiction, comma, is
Yes.
নহয়, comma, exact word to my side is. is when such a authority has assumed a jurisdiction which it does not have, or has failed to exercise a jurisdiction it does have. Or the jurisdiction, though available, is being exercised in a manner not permitted by law. Full stop. In the case, referring to the facts of the case in hand, the petitioner in his complaint has alleged that the information supplied to him were misleading and wrong. Full stop. When a party questions a failure on the part of a statutory authority to perform its statutory duties, it cannot be said that jurisdiction of the High Court under Article 226 is ousted. And the High Court, in exercise of its jurisdiction under Article 226, finds that there is failure on the part of the statutory authority to adhere to the mandate of law. The jurisdiction is can be invoked to ensure that the statutory authorities perform their duties within the bounds of law. Full stop. In the light of in view of the above discussion, this court finds that the State Information Commission, on receipt of a complaint of the nature discussed herein above, owes a duty to exercise its jurisdiction under Section 18 of the Act by taking cognizance of a complaint received from any person, including an applicant, who has exhausted the remedy of under Section 6, Section 19(1) and Section 93 of the Act, on its own merits by initiating an inquiry as contemplated under Section 18. If the complaint contains. If the contents of the complaint falls within any of the clauses from A to E of subsection 1 of section 18 of the Act. On reaching a satisfaction that there are reasonable grounds to inquire into the matter. Full stop. It is needless to say that in causing such inquiry, the commission is vested with the jurisdiction as delineated in subsection 3 of section 18 of the Act. Full stop. Para. Though this court has taken notice of the nature of information sought for by the petitioner as an applicant under the RTA Act and the information supplied to him by the public authority. On 16/10/2022 and the information supplied to him by the public authority on 13/3/2024, this court has not made any observation as regards the merits of the complaint made by the petitioner in his complaint dated 21/5/2024. Full stop. It is, but, from the text and tenor of the complaint dated 21/5/2024, from the nature of allegations, text and, from the contents of the complaint. Also, though the petitioner in his complaint dated 21/5/2024 has not mentioned under which provision of the RTI Act 2005 the state complaint has been submitted. The complaint has, however, full stop. But the same, but no omission on the part of the petitioner to mention the provision of law shall not preclude the commission to examine as to whether it falls within the ambit and purview of any of the clauses from A to F of subsection 8(1) of section 18 of the Act. In such view of the matter, the contention of the learned counsel for the learned standing counsel KAAC that the said complaint is not to be entertained because of omission on the part of the petitioner to quote the provision of law after consideration is found unacceptable. Full stop. Para. In view of the above discussion, in view of the above discussion and for the regions assigned here in comma, this court is of the unhesitant view that the commission shall take the complaint dated 21/5/2024 submitted by the petitioner before it on board and after reaching a satisfaction as to whether there are reasonable grounds to inquire into the matter shall proceed to decide as to whether an inquiry is necessitated or otherwise on its own merits. It is further clarified that this court has not made any observation as regards the merits of the complaint, meaning thereby, comma, the commission will exercise its discretion vested on it under section 18 of the Act. We'll make some correction.
But some time period may be given.
Huh?
Because my lord already is from 2020. Within a period of 3 months.
It is further observed that the commission shall, any timeline, is there any rules?
For the second appeal, there is no 18, there is no. 19/6 is the timeline for first appeal.
Generally,
Shall
it is
proceed with the matter as expeditiously as possible and the petitioner is to provide it an opportunity of being heard. A petitioner, the petitioner and other stakeholders are to be provided with a reasonable opportunity of being heard in the event the commission decides to proceed with an inquiry, Full stop. I'll think about it, about the expeditiousness.
Okay.
Well,
Proceed with utmost expedition.
preferably
You'll
within a
be,
period of 9
no,
months.
see, this timeline is, there is no timeline.
It is there, my lord, in case of 30 days. Thereafter,
It is not 6, Mr. Singh. It is 18. It is 18.
18 years. 18.
There are civil code procedure is
Yes.
incorporated in it. So some on all these are there. And it says neither the Supreme Court nor the High Court should fix a timeline to complete. Right. So we'll not do that as expeditiously as possible.
As
It
expedient.
will be provided with opportunity of hearing and it will go on its own. If really it is prolonged, then you come, we'll see to it. I'll make some correction. some cosmetic.
Like deeply obliged, my lord.
We'll deal with some section 21 or 2 line,
Yes, Lord.
just 1 or 2 line. That complaint is 1, appeal is 1.
Okay.
Both are separate.
Right, Lord.
Highly obliged.